At number 1.
In this case, this is Arthroduri Seteri. He has some personal difficulties.
Yes.
In this case, Miss Arthroduri is appearing. Yes, the personal difficulty.
Have it after, not today. Let the matter be listed after, immediately after the At number 2.
My lord, in this matter, my lord, the party has engaged senior counsel Mr. T. Mutundar lordship. My lord, he could not come to my lord court due to his personal difficulties. My lord, my friend let me start. My lord, our reply, my lord, maybe my lord enter with my lord with my.
Yes, whether the learned appellate court is justified in reversing the judgment and decree passed by the learned trial court without adhering to section 54. Read with demand where the decree is sought for right title interest over the scheduled land and partition of the moved when there is reversal of decree passed by the trial court of Yes, what is wrong with the judgment?
My lord, wrong, my lord. The section 54 lordship, that is the court, my lord, to order the revenue authorities, my lord, in case of decree of partition. Where there is a counter, in this case, there is a counter claim lordship. Case of the, my lord, plaintiff is that, my lord, 2 bigger 6 lessons of land. Original owner was my lord, 1 Lakhan Sheikh. He is sold out of that, my lord, 1 bigha to 2 persons, Abdul Qadir and Abdul Dalil. My lord, before that plot, that particular plot, after that particular plot, my lord, 1 bigha lordship was, my lord, was given to the, my lord, defendant number 1 of this chapter. My remaining 1 bigha 6 lesser lot. That was remained with the son of Lakhan Shah after his death, my lord, as the right of inheritance. Now, this Abdul Qadir, after my lord family partition, my lord giving to the defendant number 1, my lord sold my lord 1 bigha to the defendant, to the plaintiff lord.
Where is your plain?
Plaintiff's lordship is 8 plot. My lord, we are the defendants. My lord, the respondents of my lord plaintiff. My lord, suit for declaration of right title, interest of the plaintiff about the suit land, partition and exclusive possession of the purchased land of the plaintiff in the suit land, and for recovery of first possession of the suit land falling in the exclusive possession of the plaintiff on portion and separate diagonal and patta by evicting the defendants therefrom. Now, paragraph 1, very lot. That there is 2 bigha 6 kata, 0 kata 6 tasa of land covered by tag number 92 under KP Patta number 108 at village Jarabari, Moza, Bedbury within the jurisdiction of the court. Lordship. Now paragraph 3, my lord, 3 and 5.
So your case is you are the plaintiff.
No, dependent.
So the case of the plaintiff is that this particular plot of land, the plot of land in which the partition or whatever, it is not a case of partition.
No, my lord, prayer was first part.
No,
Right
they
title,
were,
interest and party
it is not a case of partition.
My lord, the prayer lordship, it is their lordship. To
Declaring the plaintiff
separate
as right
that,
title, the plaintiff will be
to create
partition
separate that.
under separate dark and this is not a partition.
My
This
lord,
is not a partition in the sense of it is a revenue partition. This is not a partition for the sense because
to
he
create
says
separate
that
lord.
this particular plot of land, which was 2 bighas, that was sold to Akbar Ali, the plaintiff, by
No,
these two
no,
persons.
My lord, 2 bigha 6 lassa. Out of that 1 bigha, my lord, as per the plaintiff lordship, was sold to my lord Abdul Qadir and Abdul Jalil. Well, that portion as per plaintiff lordship.
No. Here he says, the plaintiff says that originally the state land of 2 bighas,
Lokhon check.
no,
Yes.
of 3 persons.
Lokhon check. It was
As per the plaintiff, it is 3 persons. Lakhan Sheikh, Kedar Ali and Jalil Ali.
lordship.
And then this Kedar Ali and Jalil Ali sold 1 bigha of land to this plaintiff.
My lord.
And you tried to dispossess him and you have dispossessed him from there.
My lord, as a right of parses, my lord, page 10 of the plaintiff.
Yes,
My lord, my lord,
by
Kedar
right
Ali,
of purchase and they
Kedar
have
Ali
been
and
in.
Jalil Ali by right of parses.
So
And that is-
that was their individual property.
That is, my lord, individual, my lord, the right of purchase lordship, my lord, from Lokhon check lordship. Now 1 bigha, my lord, 6 lesser remains with Lokhon check. My lord, now question is, my lord, 1 bigha. That is my lord, total land plot from the total land plot. Now 1 bigha 6 lesser that remains with the son of my lord Lokhon Sheikh after his death. The respondent number, dependent number 4. Now the petitioner, the dependent number 1, Abdul Sattar, and these 2 persons, my lord, Abdul Jalil and Abdul Qadir, are brothers.
Who?
The dependent number 1, Abdul Sattar, Abdul Qadir, and Abdul Jalil are 3 brothers. My lord,
No. Abdul Sattar is the son of late Jonawali.
my lord, Abdul Qadir, Abdul Jalil also my lord, son of their brothers, lord.
Where
Admitted.
they are not made parties here.
Not the main party, neither they are my lord the witness in this case, lord.
Hmm?
They are not met party, neither on.
No. Mr. Ahmed, kindly tell me one thing. Whether Lakshman Sheikh transferred 1 bigha of land to Kedar Ali and Qadar Ali and Zulil Ali.
Yes, we admit it.
So there is no denial.
No problem.
Okay. So there being Lakshman Sheikh had only 1 bigha 6 lessers of land.
Yes,
You admit to that?
Yeah.
The instant suit has been filed by Akbar Ali,
Yeah.
who claims that he has purchased this 1 bigha of land from Kedar Ali and Jonel Ali.
yes,
There also there is no problem.
no problem.
And his therefore case is that he has right title and interest and you are disturbing his possession. That's it.
Yes, that is their case. Now,
How do you bring in order
Now-
section 54?
now, my lord, we file return statement, my lord, along with counter claim lordship.
Hmm.
My lord, we stated that my lord,
Let us see your written statement. of
written
counterclaim.
statement as says, that is at page 15
Yes.
lordship.
What is your written statement? Let us see. What
Yes,
is your
15.
stand? Real fact, paragraph 10.
Yes. Paragraph 10 is the real fact.
Paragraph
That
10,
the
you
real
admit
fact-
that 1 bigha of land you sold it to Abdul Qadir and Jalil Ali and 1 bigha was given to them from the extreme south of so situated at so and the defendant had no objection. The rest of the 1 katha of land of 2 remained from Lakshman in the northern part area and so mutated the names and possessing 1 bigha land. After the death of Krishna, it inherited.
My lord, only difference is lordship.
Now tell me whether there was a deed of sale executed by Kader Ali and Zonal Ali in favor of Akbar Ali.
My lord, that is my lord. I don't know. That is not my lord. That is my
You
lord.
don't know it. We are at the stage of
No.
a second appeal.
That is now that is not disputed. Now, my lord,
That
dispute
is not
that
disputed.
dispute non-existent.
No. Whether there was a sale by Kader Ali and Zonal Ali in favor of Akbar Ali.
My lord, there was a sale lord, but that is non-existing land.
I'm not on that.
Yes.
Whether that 1 bigha of land was transferred to Akbar Ali or not.
1 bigha was transferred, my lord, but there is a difference between the my lord schedule of the sale deed lordship and the my lord evidence adduced by the my lord Lat Mandal lord. That is, there is no existence of the land. My lord, from the-
No. Whether by that very sale deed
Yes.
which was transferred, there was a 1967 sale deed.
My lord, 1967, my lord, in favor of the Abdul Jalil and Abdul Qadir.
There is a schedule mentioned there.
Well, that is not exhibited. There is nothing about it.
Let us see the evidence.
Not exhibited, that is lordship. Only exhibited, my lord, this deed, my lord, that is exhibited in favor of the Akbar Ali, favor of Akbar Ali lord.
What
That
is
is-
the deed of 1904-2006 you are challenging?
My lord, that is in favor of Akbar Ali lord.
Why you are challenging that?
My lord, on the ground that, my lord, Akbar Ali and my lord Abdul Jalil had no, my lord, right of sale of that property, because that property had already, my lord, arranged in a family partition, my lord, was given to the my lord defendant number 1 during family partition. And
How can it be? How can there be a family partition can override a deed of sale?
my lord, that sale already, my lord, was done. Lord. Family partition already was done, lord,
How?
before execution of the sale deed, lord.
How?
My lord, during family in lieu of that property lordship, another ancestral property was given to Abdul Qadir and Abdul Jalil lord.
No, but Mr. Amit, tell me one thing. The basic idea of transfer of property. A family partition, somebody may give a particular land to somebody.
Yes.
No problem. But that person has to have a right over that land.
My lord, before
If he doesn't have a right over the land, it has to be affected by a registered instrument.
well, I'll come to that point.
So, was there any registered instrument?
No,
Then-
oral partition
Oh.
was there.
I could
There is my lord, a judgment of the honorable Supreme. I'll come to
tell
that
me
point,
what
lordship. Now,
what does the judgment of the Supreme Court say that by way of a family partition, a property can be vested on somebody without when that somebody had no right over the land?
my lord,
Show me that.
my lord, it is not the case of the plaintiff that the family partition was, my lord, after execution of the sale deed lordship. It is admitted by the plaintiff during evidence lordship that a part from the south of that Putton lordship, my lord, 2 bighas was given to the my lord defendant number 1
Who gave?
during family
Who?
partition. My lord,
Now, how can that plaintiff?
PW during my lord cross examination, PW 1 and 3 clearly stated.
PW1 was who?
plaintiff law.
The plaintiff
Now,
was
he-
never in the scene at the time when the agreement had happened.
My lord, hearing evidence, my lord, is stated law. If the plaintiff stated, my lord, his
Okay,
witness
now,
stated,
it is
law.
an oral partition.
My lord, oral part.
Oral-
This is the
oral
judgment of the
Show
Honorable
me.
Supreme Court law. See,
Show me that.
this is the 2015 8 at 7 to 5. My lord. Paragraph 16. My lord, it starts from, my lord, paragraph 15 law. See, that is not the position of law, my lord, and the married law. Under
Paragraph?
section 17 of the Registration Act, the documents which
Para.
my lord, paragraph starts from, my lord. This is a position of law discussed law. See, as
No.
as
Paragraph.
regards registration law. Paragraph 15. 15, my lord, vital point is paragraph is 16 law.
Hmm.
16 may I read law.
Under. Yes.
Even though recitals in Exhibit D22 are to the effect of relinquishment of right in items 1 and 2, Exhibit D22 could be taken as family arrangements, settlements. There is no provision of law requiring family settlements to be reduced to writing and registered, though when reduced to writing, the question of registration may arise. Binding family arrangements dealing with the immovable property or more than rupees 100 can be made orally, and when so made, no question of registration arises. My lord, it is admitted by the my lord plaintiff and his witnesses, lordship. My lord, 1 bigha was given to Abdul Sattar, defendant number, my lord, defendant number 1 from the south, and remaining 1 bigha 6 tasa remains with my lord Sattar. My lord, Abdul Samad. Total 2 bighas 6 tasa. This is
Kindly come to paragraph 2.
paragraph, sorry,
2 of the judgment.
paragraph 2, lordship.
Yes.
Briefly stated, the case of the respondent plaintiff is as follows. The appellant defendant and the respondent plaintiff are the sons of one late Narayana. The sold scheduled property comprises of item 1 bearing S number so and so measuring 1 acre. Item number 2 bearing S number 69 of 2007 public 70 measuring 0.25 acre, and item 3 bearing S number 69 of public 5 SC2 measuring 1 acre. Item 1 and 2 are the joint family property of late Narayana. Narayana died in the year 1962. Plaintiff 3 and 4 were working in the army and were sending money to the joint family, and the joint family affairs were run by the appellant defendant. Respondents 3 and 4 retired from the army in the year 1988 and 19 in his evidence had stated that name of plaintiff was mutated over the Suitland in place of Abdul Qadir Mia and Zolil Ali. But during
Hey,
cross-examination,
Mughal,
he
evidence
admitted
is-
that he
just 1 minute. Evidence.
had-
I'll see. How much land is there
my lord, only
in this particular dag?
my lord, it is not on record, lordship. But
No, it is on record because that is why I have asked you to stop
My lord,
there
in the deed,
because
lordship.
that is exhibit 2.
lordship, actually, he sold it.
No, exhibit 1 is the sale deed. Exhibit 2 is this.
My
See,
Zamamondi, lordship.
Lakshman say the total land is how much?
Zamamondi,
92, 2 bighas soil asa.
my lord.
Then
My lord, 2 big.
Then
That is
why
why.
you are saying some other lands?
That is why, lordship. That is why.
Then you-
What is the boundary? What was
Then
the-
it may be at best a case of that finding out the exact portion. You give some portion of your lands if that is
My
so.
lord,
But
What?
I would have understood that this particular plot of land had some other, was a very big plot of land. There were many other people out there. No,
my lord,
the total
Our
land out
plead-
here, Mr. Ahmed, is only
Our
2
pleaded
bighas,
case,
6 lessers.
it is our specific pleaded case that the purchaser Abdul Qadir and Abdul Solil, my lord, had cleverly shown different plot of land from this, my lord, because this plot of land already under occupied. But that is the case, lordship.
I am
Pleaded
not
case,
concerned
lordship.
with occupied,
Now, my
not
lord, my
occupied
lord,
out there.
evidence
business.
discussed, lordship. This may be
Kindly see here the sale deed which was there as exhibit 1 proved in original. Here it has been given that here Topsil Bikrita Mati Topsil Hole so and so Notun and Uttore Kitab Ali Kitab, who is this? Ibhag Ali or something?
my lord, South kindly see, lordship.
No,
South Abdul
not,
Sattar. My lord,
no,
vivid number
no,
number
not,
1.
no, Uttore from Kitab Ali or something. Kitab Ali. Dokkine or
Dakhine Abdul Sattar, lordship. Abdul Sattar, man, he.
no. There is no Abdul Sattar
No,
here.
Abdul-
Akbar Ali.
My lord, in the, my lord,
See the sale deed, exhibit 1.
my lord,
See the Sohor.
my lord, South, lordship.
Not. Dokkine.
My lord, sale deed is not with me, lordship.
Then you are trying to say
Now,
about
my lord,
this
plain
thing.
deed is, my lord, kindly see Suitland in the plain, lordship.
No, I am not concerned with that. See the sale deed. Exhibit 1. Ube,
My lord,
Sokhat Ali.
Ube Sokat,
Ube. And Pussime, Hazrat Ali.
lordship. What's it?
Who is these people?
My lord, Hazrat Ali, my lord, they are neighboring people, lordship. Now, 1, 2 names are there. Samad and my lord Abdul
এই
Sattar should be here.
চৌহদৰ মানুহ মাতি এই
সমাধান-
দলিলৰ উত্তৰ ইমান পশ্চিমৰ জৰিয়তে শুনোৱা হ'ল। বাকী কিমান? So the sale deed is there properly.
My lord, if that is so, lordship,
Hmm.
if that is so, kindly see the, my lord, schedule of the, my lord, plain, lordship.
Huh?
If that is so, lordship,
Hmm.
kindly see schedule of the plain, lordship.
Hmm.
That is different law.
Hmm.
My lord, with the north,
Hmm.
north, my lord, Kader Ali and others.
Where not
South
Kader
Abdul
Ali?
Sattar, lordship.
No.
We schedule land.
No.
We
Kindly
schedule
come to
land.
page 14. Kindly come to page 14.
14, lordship.
It is mentioned as Kitab Ali.
We schedule land. Abdul Sattar, lordship.
Katab
South,
Ali.
South. Sorry,
It is Uttara, it is mentioned as
North Kitab Ali,
Ali.
lordship. It's okay, lordship.
Huh.
South, lordship. Abdul Sattar Ali.
South, Abdul
Sattar Ali.
That is also same. Abdul Sattar
Abdul
Ali.
Sattar Ali.
Ah.
East, Samad Ali.
Ube Samad Ali. Yes, okay.
My lord.
And
West, Hazrat Ali.
yes.
Now, lordship, Why I am saying lordship? South, that is south, my lord, the land, suit land is 1 bigha lordship. In the southern portion, lordship, Abdul Sattar, 2 bigha, out of 2 bigha, 6 lessons, Abdul Sattar in the southern portion. It is admitted by the plaintiff, my lord, in the evidence, lordship. If Abdul Sattar in 1 bigha from the southern part, lordship, then my lord, 1 bigha 6 lessa, that remains with my lord, Lokhan Sheikh, lordship. After his death, remains with the defendant number 4, Samad. My lord, what my humble submission, my lord. Where is the land, my lord? For sale to the my lord Akbar Ali lordship, to the purchaser Akbar Ali lordship. There is no existing land, my lord, because it was already, my lord, occupied lordship. So after occupation, my lord, the my lord, 2 persons, my lord, Akbar Ali and Abdul Jalil, my lord, cleverly executed a sale deed lordship. That is not, my lord, free from occupation lordship. My lord, it is stated lordship. It is stated. Kindly see evidence lordship. It is clear, very clear lordship. Evidence of PW4, my lord, Lat Mandal lord. He says that the boundary is different lordship. Not this. Lat Mandal, my lord, is the appropriate person, my lord, to determine the position of the land lordship. My lord, in this, it is stated, my lord, by the discuss. It is discussed.
Okay, then further go. Yes,
My
page
lord.
31.
Page 31 lordship.
In support of the plaintiff's case, he adduced the
Sir,
evidence of the Lakmandal,
but-
who in his evidence has stated that the name of the plaintiff was mutated over the suit land in so and so. During cross-examining, he admitted that he had no knowledge who is in possession of the suit land and paid the law. On the other hand, PW4 and so was examined to prove about the execution of the said. That has crossing discharge and confirmed the boundary mentioned in. There is no dispute about the execution of the sale deed by Abdul.
It is discussed. It is
Whether
admitted lordship.
these
PW1.
vendors have any right to sell the suit land to the plaintiff. Again, PW2 You are appearing for
My lord, counterclaim lordship, defendant lordship.
defendants included Abdul Sattar.
Abdul Sattar and Abdul Samad lordship.
You are appearing for Abdul Sattar, Abdul Samad,
All
everybody.
defendants.
So you have to give the land then. Anyways, you have to choose whom do you like more.
My lord, there was a counterclaim that the 1 bigha 6 katha, my lord, may be declared, my lord.
So what happened in the first appeal?
Well, in the first appeal, my lord, declare, dismiss the suit, my lord,
Dismiss the suit.
yes, lordship. Dismiss the suit, my lord, allowed counterclaim, lordship.
So then why are you before this court?
No, lordship, I am not. In the first appeal, lordship, title suit was, my lord, in the first trial court, lordship, my lord, the suit was dismissed, lordship, my lord, the counterclaim was the allowed. Thereafter, my lord, the plaintiff filed appeal, lordship. In that case, lordship, there is no finding in my lord counterclaim. There is no specific appeal against counterclaim, lordship. The counter in this suit, my lord, declared that the defendant number 4, Abdul Samad, has right title interest over the plot of land 1 bigha 4 lesser lordship. No, so sorry, 6 lesser lordship. And specifically that was not challenged, my lord, because there is a settled position of law that the my lord counterclaim, findings in counterclaim lordship should be, my lord, specifically, my lord, challenged, my lord. There is judgment of this honorable court also, lordship, that it should be today, my lord, I have not taken that judgment, lordship. it should be treated as separate suit, lordship. Now that is not challenged, my lord. There is no specific finding. Only, my lord, reverse the judgment passed by the learned trial court, lordship.
So was the counterclaim's judgment being reversed also?
My lord, that is there is no specific finding in the my
No,
lord,
no, let us see.
lordship.
Let us see.
My lord, the finding as regards one week as 6 lassa, that was reversed.
No, 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 no. Let us
That
see.
was reversed. My lord, issue number 6, page 65. Issue number 6, page 65, lordship.
In the result, the appeal is allowed, the impugned judgment and decree and the appeal is set aside. The suit of the is decreed so and so. It is further ordered and decreed
Order,
for
lordship.
delivery of thousand let year so and so, so and so. The point for decision and so and so. Only so and so. It is clear.
Now, my lord, in order there is no such, my lord, things that the counter claim was, my lord, dismissed. It should have been dismissal of the counter claim if the appeal is allowed, lordship, in both plaint and counter claim, lordship. However, reversed, my lord, 1 week 6 lassa, lordship, finding as regards 1 week 6 lassa in favor of my lord, defendant number 6, 4, lord. But there is no appeal against the my lord counter claim. The judgment passed by the learned trial court, my lord, is very clear, lordship. Here.
Page 64 and 65. Issue number 5 was decided against you.
Lordship, my lord, as regards against defendant number 4, Lordship,
Huh? No, issue number 5 was decided against you.
64, Lordship. In view of, Lordship,
Hmm.
in view of what has been discussed about the findings of the learned trial court in issue number 5 declaring that the defendant number 4 has right title, interest, and possession over the suit land is contrary to and against the weight of evidence on record, and hereby the learned trial court came to a wrong finding on issue number 5 as the defendant number 4 has failed to establish his right title, interest, and possession over the suit land by preponderance of oral as well as documentary evidence on record.
And
the
issue
finding-
number 6 has also been decided against you.
Lordship,
That,
That is-
therefore you are not
lord.
entitled to the counterclaim.
my lord, submission is that, my lord, this is, my lord, in common, my lord, judgment is given, Lordship.
Very well. How many appeals you have filed?
Appellants, my lord,
How many appeals you have filed?
one file, Lordship.
No, your counterclaim was dismissed.
As there's no appeal before the separate appeal before the
So
lord.
how can you raise that issue then?
My lord, because my lord, the separate appeal was
Did
not
you
filed.
raise that issue that there should be 2 counterclaims, 5 appeals?
Position of law, Lordship.
No, it is not. Have you raised that
That's the
issue? There?
position of law,
If you have not, have you not waived it?
not raised. My lord, position of law can be raised at any time, Lord.
I think
Now, anyway, Lord,
these
Is that
matters,
apart from that law,
these matters needs a further adjudication by the Supreme Court. Let me dismiss the appeal.
my lord, apart from Lordship, my lord, my lord has been, my lord, specifically
How does the question of law number 1 arise? No, it is a pure and simple case of right title in interest and delivery of possession and recovery of possession.
My lord, kindly see the prayer, Lordship.
I have seen. Do you
Well,
understand?
partition,
Mr.
prayer of
Ahmed, the
partition,
prayer
right?
which has been made is that once he gets over this possession, there has to be a partition, that the precept be issued to the revenue authority for the purpose of partitioning and issuing a separate DAC for that.
No, why?
Because it was a
my lord,
common dag
why-
which was
my lord,
sold.
Why that is important? Why that is important?
That is not a partition in the sense of Order 20 Rule 18. That is not a partition in terms with Section
My lord,
54.
My lord, the substantial question of law, my lord, was framed, my lord. In that context, my lord, because there is a counterclaim saying that there is no the land sold to the my lord to the my lord plaintiff, my lord, is not in existence, my lord. This is non-existence land, non-existing land lordship. That is why, my lord, the revenue authority is required to find out the land lordship. My lord, that is why, my lord, that direction is required. My lord, in my humble submission, lordship, my lord, is required now.
Heard
Now,
Mr.
my lord, kindly
Ahmed.
see the evidence. It is
Heard
my lord,
Mr. Ahmed. Mr. Ahmed, I have given you
only
almost
two,
one.
my lord, two lines, my
No,
lord.
no
evidence.
more, no
Lordship,
more.
only
1
two
hour
lines.
is too much in a
My lord,
second appeal.
PW 1 and 3 kindly.
No,
My
no,
lord, it
no,
is a-
no. I have looked into it.
My
Nothing.
lord, question of perversity is there, lordship. My lord, that is substantial question.
You
of law.
show me any document to show that there was a deed of exchange, a registered deed of exchange between Abdul Sattar and the other defendants.
That is not there.
Okay,
For a
that
moment, my lord. For a moment, my lord. This is a
Secondly,
judgment in
no, no, no,
regards-
no. Secondly, you show that you have given evidence that it was a joint family. Out of the joint family income, the amount the Kader Ali and Jonel Ali purchased the land.
That is not. Kindly see, lordship. Kindly see 2 lines evidence.
Mr.
My lord,
Ahmed,
it is a
no,
judgment in
no,
reverse.
I'm not showing.
My lord, what
No,
am judgment
sorry.
in reverse? My lord,
Heard
2 lines, my
Mr.
lord.
Amic.
My lord, for 1 minute,
Mr.
my lord.
Ahmed,
Lordship, 1 minute,
enough.
my lord.
Sit down. Heard Mr. M.H. Ahmed, the learned counsel, appearing on behalf of the council, the appellant. You are
My lord, I
S. Ali,
would
appearing
like to
on
submit
behalf
that,
of the
lordship.
respondent. The instant second appeal was admitted. By this court by an order dated 28/5/2010 by formulating two substantial questions of law. Which are reproduced herein under. A2 28/5/2010 or 5. For ascertaining as to whether the two substantial questions of law as formulated by this court arises in the instant appeal, this court finds it relevant to take note of the brief facts of the case. It transpires from the materials on record. It transpires from the plaint. For the purpose of convenience, the parties herein are referred to in the same status as they stood before the trial court. The respondent herein as plaintiff has instituted the suit being title suit number (6/2006) before the court of the Munsif, Borpeta. A perusal of the said suit, a perusal of the plaint reveals that the Schedule A land originally belonged to one Lakhon Sheikh, number two, Kadar Ali Mia, and number three, Jolil Ali. It has also been averred that Qadar Ali Mia and Jolil Ali had purchased 1 bigha of land out of the scheduled land, Schedule A land, by the registered deed of sale on 29/5/1967. And thereupon, their names were duly included in the Jamabandi of Dag number 92, covered by KP Patta number 108 of village Zorabari, Gaon, Moza, Betbari, district Borpeta. It further reveals from the plain that by the registered deed of sale, bearing deed number 44406 dated 17/4/2006, late Kader, the said Kader Ali and Jalil Abdul Jalil transferred one bigha of land which have been more specifically described in Schedule B to the plaintiff. And the plaintiff was also handed over the possession of the suit land, of the Schedule B land. However, on 12, it is alleged in the plain that on 12/5/2006, the defendants trespassed upon the suit land, Schedule B land, and dispossessed the plaintiff. It is under such circumstances the suit was filed for declaring the plaintiff's right, title, and interest over the suit land, which is the Schedule B land, for recovery of khas possession of the Schedule B land, and further that the land in Schedule B be partitioned under a separate dag and separate patta, and in the exclusive possession of the plaintiff by evicting the defendants from the Schedule B land, falling under the exclusive title and possession of the plaintiff on partition. At this stage, it is relevant to take note of that the relief of partition so sought for is only for the purpose of allotment of a separate dag and patta, thereby carving out the Schedule B land from the Schedule A land. The said partition is not in respect to a proceedings under Section 54 or a decree in terms with Order 20, Rule 18 of the Code. Be it as it may, all the next all the defendants submitted a joint written statement and counterclaim. Hey, file A to D. I'm coming in 5 minutes. Along with a counterclaim. In the said counterclaim, in the said written state, no, in the said written statement, more particularly at paragraph number 10, it was an admitted fact that Lakhon Sheikh had transferred 1 bigha of land to Abdul Qadir and Abdul Jalil, and the said purchasers, that is Abdul Qadir and Abdul Jalil, mutated their names and were possessing that 1 bigha of land peacefully. It was further averred in the written statement that after the death of Lakhon Sheikh, his son Samed Ali inherited 1 bigha 6 lessers of land situated at the northern side of the plot of 1 bigha of land, and was possessing, cultivating peacefully. It was further mentioned that Abdul Qadir and Abdul Jalil had, on the basis of a family partition, handed over the plot of land measuring 1 bigha to his brother Abdul Sattar, the defendant number 1, in lieu of his ancestral property. And the said Abdul Sattar was possessing the 1 bigha of land by constructing house, digging ponds, and making shop houses It was further mentioned that the boundary mentioned in the deed of sale bearing deed number 444/06 dated 17/4/2000, dated 17/4/2006 was not the correct boundary. And the plaintiff never possessed the suit land, even for a single hour. And the entire suit so filed was false. Full stop. It is relevant herein to take note of that though a counterclaim was filed, and various reliefs have been sought for, but the same counterclaim which as per Order 8, Rule 6A, bracket 4, requires the counterclaim to be treated as a plaint and governed by the rules applicable to the plaint, was not in terms with Order 7, Rule 1. Inasmuch as the counterclaim was not valued, inasmuch as there was no statement of the value of the subject matter of the counterclaim, ito na lang. Relevant to take. It further reveals that to the said counterclaim, there was a written statement filed by the plaintiff on the basis of the said pleadings. As many as 6 issues were framed. Which are as under page 28 of the body. During the course of the trial, as many as 7 witnesses were adduced by the plaintiff and various documents were exhibited. The defendant, on the other hand, examined as many as 4 witnesses in favor of their case. At this stage, this court finds it relevant to take note of that Exhibit 1 was the deed of sale bearing deed number 44406, dated 17/4/2006. Exhibit 2 is the Jamabandi of dag number 92 of covered by KP Patta number 108. A perusal of Exhibit 2 shows that the total land in dag number 108, 92 of KP Patta number 108 consisted of 2 bighas, 6 lechas. 0 katha, 6 lechas. It further transpires that the name of Kader Ali and Jalil Ali were also included therein along with Lakshman Sheikh. The learned trial court, by the judgment and decree dated 3rd of September. By the judgment and decree. 3rd of September 2008, dismissed the suit of the plaintiff and decreed the counterclaim on contest, thereby declaring that the sale deed number 444/06 dated 17/4/06 as invalid, illegal, inoperative in law, and the defendant number 4, Abdul Samad, had right, title, and interest and possession over the Schedule B land, which is specifically described in the plaint. Being agreed, the plaintiff preferred an appeal before the court of the civil judge Borpeta, which was registered and numbered as title appeal number 43/08. In the said appeal, the judgment and decree passed by the trial court was set aside by holding that the findings arrived at issue number 345 were contrary to the well-settled principles of law and were based upon perverse findings. Further to that, the issue number 6, whereby the trial court dismissed the suit and decreed the counterclaim, was also set aside. At this stage, it may be relevant to take note of that the issue number 3 related to as to whether the plaintiff had right, title, and interest over the Schedule B land. And issue number 5 related as to whether the defendant number 4 had right, title, and interest and possession over the Schedule B land. The learned First Appellate Court, taking into account Exhibit 1 and Exhibit 2, had come to a finding that the plaintiff had right, title, and interest over the Schedule B land. As the entire edifice of the case of the defendants was on the basis that Kader Ali Asinigi, Abdul Kader and Jalil Ali,
Yes.
had given the Schedule B land to Abdul Sattar. That is the defendant number one, in exchange of some other land. And the same said aspect of the matter having not been proved, the first appellate court therefore held the issue number 5 issue number 3 and issue number 5 against the defendants. It is against this judgment dated 5th of September 2000, judgment and decree dated 5th of September 2009, that the present appeal has been filed. And this court, by the judgment and decree dated, this court, by the order dated 28/5/2010, had admitted the instant appeal by formulating the two substantial questions of law as above quoted. Next. The first substantial question of law, I've heard the learned counsels for the parties and perused the records. The first substantial question which have been framed as to whether there was a necessity of adhering to the provisions of section 54 read with order 20 rule 18 of the code while passing the judgment by the first appellate court, when the decree sought for was for right title and interest over the suit land and partition of the Schedule B land, and for recovery of cast possession of the Schedule B land. In the opinion of this court, taking into account the prayer sought for, and in the opinion of this court, a perusal of the plaint as well as the relief sought for would show that the plaintiff had sought for right title and interest of the Schedule B land and for recovery of possession of the Schedule B land. Further to that, the plaintiff had taken into further to that, the plaintiff sought for a precept upon the respondent, sought for a precept that the Schedule B land, which is a part of the Schedule A land, be curved out and be allotted a separate path and dark number. In the opinion of this court, the said relief do not come within the ambit of section 54 of the code, as well as under the provisions of order 20 rule 18. Inasmuch as the said provisions would have come into would have been applicable if there was a partition sought for in respect of Schedule B land, In that view of the matter, the first substantial question of law so framed in the opinion of this court is not a substantial question of law arising in the instant appeal. The second substantial question of law relates to as to whether the reversal of the decree passed by the trial court on the basis of the findings under issue number 6 to be perverse as held by the lower appellate court is valid and correct. In the opinion of this court, cannot be regarded as a substantial question of law, as the same is a question of fact, which the first appellate court, having the authority and power to exercise the power of reappreciation of evidence, have done so. The learned counsel appearing on behalf of the appellant, though submitted, that the first appellate court did not take into consideration that the southern boundary stated in the plaint as well as also in the sale deed included the defendant number 1, which was not permissible, which couldn't have been, which could not have been possible. In view of the fact that the land which was sold to Kader Ali and Jalil Ali was transferred to the defendant number 1. And as such, the defendant number 1 could not have been on the southern boundary of the land sold by Kader Ali and Jalil Ali. In the opinion of this court, the said submission is misconceived, more particularly in the proceedings under section 100. When the first appellate court, on due appreciation of the evidence, had come to a finding that the land in Schedule B was transferred by Kadir Ali and Jalil Ali to the plaintiff by the deed of sale. And more particularly, when the first appellate court had categorically negated the stand more particularly had negated and more had rightly negated the stand of the defendants. That there was any negated the stand of the defendants. That there was any to the effect that there was a transfer by Kadir Ali and Jalil Ali in favor of the defendant number one, which the defendants had failed to prove. In view of the above, this court is of the opinion that the substantial questions of law which have been formulated by the learned trial court by this court on 28/5/2010 do not arise in the instant appeal. Consequently, the instant appeal stands dismissed. The registry is directed to prepare the decree and thereupon forthwith transmit the records to the trial court. Hello.
Hello, only 1 week, 1 week or 6 Tesla worship. That, my lord, it is not.
Tell me one thing. No, tell me one thing. How can you claim what you are? Defendant number 4 was Samad Ali.
Yes.
He had the land.
Ancestral.
There is
property.
no quarrel that he doesn't have the land.
That observation may be given. I should, ancestral property, as regard that cannot be, my lord, negated loss.
I'll add that one line. The defendant number 4's one because 6 lesser is there intact.
That may be lost.
I'll put it. Game order doesn't survive there.
Note 3.
All right, Judge.
Yes, after a long time, MAC,
Yes, my lord.
what is there?
My lord, there's an award in emissary court. My claimant side is there, my lord, in her favor. But there is direction that it should be recovered from the owner.
Huh?
Owner, not from the insurance company. So against that we have
In the
come.
light of so and so only from the owner and driver of the offending vehicle. Owner and driver directed to pay the seat amount. Yes,
So my lord, I have got my due policy. The insurance manager wrongly cited that there is no policy. He gave the evidence, he issued the policy in my favor.
and
Subsequently said
what does
second-
the court say?
Court said that original this policy which was covering that period was not proved, but second policy was proved, which is not required. But I have brought here, I have given it here.
Where?
Before here, I have and put it here also, my lord.
You have given the secondary evidence, additional evidence.
No, we have not, because after the award, we have come to know that my policy was seized by the police as well as the investigating officer. So I was in the notion that my policy is there, but when we have executed, wrongly, my lawyer has executed the second policy. That is a new policy. That is a continuity of the policy.
Now, did you file an application under order 41/27 here?
There I have not done anything.
Here,
Here I have not done, my lord.
then how can I take that document?
My lord, I have filed this here because insurance company who has issued the license policy, he knows it. How he has said that I have not.
Oh,
We have no
whatever
policy.
may be, but Mr. Biswas, don't you think that how can I take this document without you bringing on record that document by way of an application?
Order 41 I have to do it.
You did not bring it before the trial court.
Yes, I have not.
Here you have to bring it.
If we short break, but right.
Mr. S.C. Biswas, the learned counsel, appearing on behalf of the appellant and so for
Claimant.
appears for the respondent number 1. Mr. S.C. Biswas submits that the insurance policy relevant for during the period of the accident was seized before, during the pursuant to the accident by the police.
Yes.
And as such, inadvertently, the claimant's lawyer before the tribunal had exhibited the subsequent policy. He submits that though the tribunal had held that the subsequent policy would be not material, for which the award was passed in favor of the claimant, but against the owners. But there was an existing policy which the claimant or the appellant seeks to produce before this court. This court is of the opinion that if the appellant wishes to produce any additional evidence, the same needs to be done in terms with Order 41, Rule 27. Accordingly, the learned counsel appearing on behalf of the appellant seeks for an accommodation for 2 weeks. List the matter immediately after the summer vacations.
Another 4.
Yes, why it was before the division bench? Oh, this is a matrimonial appeal. Then? No, nowadays matrimonial, this is by the district judge. The district judge is here. Now where? You are the divorcee. You are the respondent means wife. You got the divorce. And where is the appellant? Appellant's name is Mr. Dilip Mojumdar. Mr. S. Biswas. Why? What was the ground? Period of? No. Oh. This person is retired. So they are still interested in pursuing this. He's 64. Oh, and what he has some issue after the marriage with the second one. So that if the divorce is not given, no, legalize is okay. What will happen to that son? He'll be entitled to the benefits, but he will be an illegitimate because the marriage would be. But here the daughter will also be legitimate, and if the marriage is okay, then this marriage will also be okay. So why don't you both think about it? It is only the question of now everything is on the question of legitimacy. So that is the major thing which, apart from others, there is nothing else. It will only confer a legitimacy to the second wife. So this was filed in the year 2019. He was 64. Now he's 67. And his wife must have been something. No, not you. The other one. Oh. Some legitimacy it will confer only if a divorce is given. Only the thing is she may lose out for the pensionary benefits. Marriage, there is already there. Understood, he has made the mistake, but then also you have to think about the legitimacy of that also. Hmm? No, but this court can't do anything on that unless it is a case of because this court can't, that is a power which the Supreme Court otherwise can, unless you have a mutual. No, understood, but then also it can still be made mutual. With a period of time, this was filed in 2016, it's okay, but now 7 years have gone by. Temporary judge for these matters. Anyway, and none appears on behalf of the appellant on call. Mr. G. Chaudhary appears on behalf of the respondent, taking into account that this being a matrimonial appeal, a further chance is given to the respondent to the appellant to appear. Least the matter after the witness, the summer vacations.
Five,
Please, Your Lordship.
Yes, Mr. Chairman.
My lord, before your lordship takes up this matter for hearing, it is my duty to point it out, my lord. This
Hmm.
matter was substantially heard by different ways, although part heard was not reflected. Lordship, have a look at the order passed on 26/4 and 25/5. Okay, Lord. So, part heard. is not been recorded,
Okay, tell me what is the case?
my lord. So, this is a case where an arbitration award was passed in favor of the railways, and subsequently on the 34th, that was set aside. We are against the order of the learned district judge setting aside the award.
Where is the order?
Month.
Page 28.
Page 28.
What is the ground of setting aside?
My lord, here the facts are like this, my lord.
Hmm.
The construction work was given for contract agreement for construction of a BG tunnel number 11 of 600 running meter in Jiribam and Tupul railway section. Now, the contractor did not initially commence the work, then extension was granted, and the extension was granted up to 31st December 2013. However, on 28/2013, that is during the extension period, the contract was terminated. However, it was done by following the provisions of the contract agreement. Now, the award was passed
Let us come to paragraph 20,
of,
the judgment,
well,
page 35. It extended the time for completion of the work up to so and so. But thereafter, by letter dated so and so, the
Yes, my
respondent terminated the contract for 4 months before expiry of the completion period.
yes. No. Here, the
And-
arbitrator in the proceeding has recorded a finding on perusal of material that on the date on which the termination was made, the contractor had not even commenced the work. No. So there was no nil work,
But you are railways, na?
my lord.
You give this 7 hours, 48 hours notice, na?
Yes, that was done. Procedurally, there is no.
No. Before that also,
Yes,
termination, did you
Yes.
go for that?
yes, it was done. That
Then?
is 7 hours, the file, my lord, first 7 days notice. There was another 7 days notice, then 48 hours notice.
And this extension which was given
Hmm.
on
On my lord, at the request of the contractor.
when?
Extension, my lord, was given on 6/2/2013.
6/2/2013.
That the 6/2/2013 was the letter of the contractor seeking extension. However,
What
it
is the
was,
order of extension?
it was granted on 24/4/2013. Up to,
Where is the document?
my lord, perhaps it will be there in the
Hey,
record.
file it. Must have been written out there that if you fail to do proceed, we are going to terminate then. In the termination, that is normally written. Or I don't know, your railways, you railways do whatever you feel like.
But the fact remains, my lord,
After God, railways are there. Yes.
my lord, the fact
Where is
remains,
that document? Don't say you are not prepared.
my lord, that I could not go through it.
Huh? That is the document we are concerned. Where is the extension letter? Mr. Counsel? Extension letter is where? Huh? No, not the termination, I am concerned. I am asking about the, where is the extension letter? By which you have been given an extension to do, complete it on a particular date. That is your entire edifice of your case is that this was a particular letter which was issued, thereby extending the period till 2023.
No, my lord,
And-
13.
Huh?
31st December 2013.
Oh, yes, 2013,
13.
but they terminated on 28. Where is that letter? 13, where is the document? That document number is dated what? What was the date you said?
24/4/2013
24/4/2013.
and
Let us
extension
see.
up to 31st/12/2013.
With reference to assert the enclosure of the NPL letter is action Madhupan. Wait. Construction, 6th of February 2013. What does it say?
Is the letter of the contractor seeking extension.
You applied. Let us see that document. Where is this? You have given 28. No, where is that document? The work was assigned to you by the acceptance letter with a completion period of 13 months time, that is by 8/2/2013, which was extended up to Iman. By progress of the work has been shown no significant improvement within the DOC period. What is the DOC?
Date of completion.
For which 7 days notice followed by 48 hours notice were issued by you by this letter referred to above, but you have failed to make good your default to show adequate progress. Due to failure on your part to fulfill the contractual obligation, the work dated so-and-so is terminated with effect from so-and-so in provisions of section 62 and so-and-so. And for your full so-and-so stands forfeited. Very well. But that letter is relevant, no? By which it was extended. Was that not brought before the arbitrator? You say, Mr. Chakravarti, that the matter was heard twice by this court, and you don't know. Huh? This is the main document. And you are claiming on that 31/12/2013. Where is that document? You have made this application. Where is that part of the award?
My lord, the award starts from page 12.
Page
12
where is it? Of
of my appeal, my lord.
arbitrator's record is there.
Yes.
Where is that? Oh, arbitration record is not here. Not here? You say the matter was heard.
My lord, the reasoning of the arbitrator, your lordship will find at page 17.
Wait, the award will be somewhere.
The award of the arbitrator is annexed, my lord, in my memo. of appeal.
No. We don't trust what you do. Where is the document? We are not finding it. We have filed this appeal here. Yes, I think we got it. Statement of claim. Refund. Bank change. Who is the arbitrator? So the record is with you.
My lord, it is with the arbitrator, my lord, with the district court, my lord.
Huh?
The records of arbitration were produced by the district court. On the 34, when the proceeding under 34 was going on.
Or these three arbitrators?
Yes.
Show me. Where is that? Arbitrator, what did he hold? Where is it?
It starts from page 17.
Page?
17, views and findings of arbitral tribunal,
No, that relevant portion.
relevant portion.
The contract was
Wait,
awarded on.
My lord, may come to page 17, last paragraph. Even though the work was awarded in the month of January 2012, but the claimant had not done any work before monsoon and also even after the rainy season was over in October. The road construction started only in June 2013 when the monsoon had set in. Thus, there was total negligence at the site work. The road was also not complete at the time of termination of contract. The contract was extended up to 31/12/2013, taking into account all post major factors like rainfall, blockade, militancy, etc. Thus, the contractor was allotted ample time to complete the work up to 31/12/13, but till the date of termination, the claimant had not even completed approach road and no work started at tunnel portal site. Whole working season had passed, but no work on tunnels started. The claimant could have started the tunnel excavation on one end, which was just at the start of the railway yard, where no road construction was needed. But the claimant is taking the plea of construction of approach road, which is mainly because the claimant had done no preparation for the tunnel work and was just wasting the time. The claimant had not brought any tunnel excavation equipment like boomer, shotcrete machine, etc. This clearly shows that the claimant was not serious about the starting and completion period of the work. It has become quite clear from the proportionate progress of the claimant that the claimant would not be in a position to complete the work within the allotted time. There was no point to wait till the expiry of the allotted time. Since the ample time had been given to the claimant, and after finding that the claimant was not taking keen interest for tunnel construction, the contract was rightly terminated on 28/13 by following the contractual provisions, as project was of national importance and being monitored by Railway Board and PMO.
What was the project?
My lord, railway line from into Manipur, my lord.
Oh, now train goes to Manipur.
That was going on, my lord. Train goes, yes.
It's still under construction.
This is a tunnel in the Jiribam Tupul section, my lord. So, my lord, my submission before
But
lordship
Mr.
is,
Chakravarti, the most important document, did they take into consideration which had extended the period till 31/12?
it was extended.
What was the reason? Why did you give 8 months at the request? The only issue, we are not concerned about all these things. You are making the file big or short. The simple issue is, if you have extended till 31/12, why did you exercise the power on 28/2013? Unless in the letter by which it was extended till 31/12, you reserved your right to do so.
My lord, in before,
Huh? Understood. Mr. Counsel, these aspects are all understood. You see section 17, section 17A, where it will be extended. These aspects of the matter, I would know that. But the only thing is, whether the tribunal or even the courts took into consideration that what was the reason why it was extended till 31/12. Did they reserve any right to terminate if during this period there is nothing shown for the purpose of they had power, nothing, substantial improvement is not shown, because normally this is being done. Where is the document? And if the arbitrators have decided that without the document, which is apparent, without looking into that document,
my lord, after the extension, twice notices were given for them
Understood.
to improve their work, and they have not
Understood.
done.
Understood. When do you issue notice of 7 days and 48 hours?
When no work is noticed or the progress is
So
substantially poor.
can you issue notice even prior to or after the period is over?
My lord, during the progress of
Let
the
us
work
see,
also.
let us see the clause. Where do I get the clause? Yes, got it. Read 43. Which Hazira 43. Well, this is extension. Let us see 62. What power they have? Where is 62?
একটু দিয়ে দেবো না?
This is under 62.
On one side,
No,
it is-
where is the 7 days, 48 hours? Huh? This is also picking and choosing of only some provision. Where is the provision of 7 days and 48 hours?
is there in the contract. My lord.
Huh? Really? Got it. Then in any case, the engineer on behalf of the railway may serve the contractor with a notice in writing to the effect. The correct information in but not within 7 days after the delivery of such may proceed to make good his default insofar as the same is capable of being good and carry on to complete. Because you see, the arbitrator did not take into consideration that what happened after the 7 days and 48 hours.
No, arbitrator has.
No, there's nothing mentioned. That after 7 days also they did not improve. There's nothing mentioned out there.
My lord,
When was the 7 days notice issued?
my lord,
Does the arbitrator say?
1907.
Don't come up with all these things. Where is it in the arbitration award?
Ma-
Then
My lord, I'm coming to
what is wrong? Arbitrator did not look into those aspects. Railway arbitrator. Which one?
My lord, the counterclaim is nothing but the encashment of the security deposit.
But how could you do that 5 days before the
No, my
award?
lord, it is they are saying, but it is not that. It was filed along with the claim.
You get all the. You have the records.
No, my lord, the records of arbitration is
It can't be. All the other aspects are here. The records of arbitration is not there.
in any case, my lord. under the arbitration agreement, my lord, forfeiture of security deposit and is there in section 62 only, clause 62.
Everything, but provided you have legally terminated.
Yes,
But legally terminated, did the arbitrator take into consideration after 7 days you have not done anything? Where is that? Or should we shut our eyes to whatever the arbitrator does?
no, my lord, it can't be. But the fact remains that the reason
dismiss-
given by the arbitrator,
So we dismiss it?
no, my lord.
Anything else?
My lord, the reason given by the arbitrator is that they have not done any work in the tunnel site. So,
No, I'm not on that. You have given us 48 hours, 7 days notice.
my lord,
And there you will ask that there is some improvement you make. Obviously, when you are issuing a 7 days notice, you can't say that you can't complete it by tomorrow because your period of ending is on 31/12. And then there has to be a decision that within these 7 days also you have not done anything. And for which the 48 hours is given, that show us some progress.
no progress was noticed, my lord.
So where is that finding that after the 48 and 78 hours, 7 days, there was nothing?
My lord, lordship, I'm just pending it on my, I've seen
Or
somewhere.
Mr. S. Chakraborty, the learned counsel, appearing on
I've
behalf.
seen somewhere, my lord.
Huh?
I have seen, but the problem, my lord, the records are with
And
the,
Mr. Yes, so and so the learned counsel appearing on behalf of the respondent. Upon perusal of the materials and of the report, this court do not find the records of the arbitral tribunal It is the opinion of this court that without the records of the arbitral tribunal, the instant appeal cannot be proceeded therewith. The learned counsel appearing on behalf of the appellant submits that he shall take appropriate steps in that record for bringing on record for calling of the arbitral tribunal records and shall take appropriate steps so that the arbitral records are made available before this court. List the matter again on when?
after repeat.
On 25th of July, along with the records.